My lord, I appreciate you're the only one. And really, I really appreciate...
My brother is also there.
I really appreciate you bending over backwards. But my submission on that basis was merely to demonstrate the speed with which I would like this to be dealt with. But of course, I know that this honorable court is saddled with very many petitions and applications. I'm aware of that. But what I'm saying is, for this petition who came rushing to you, rushing on the certificate of urgency, oh, the house is burning, we are in jeopardy. But now he's the one they're the ones who are holding back and says, okay, let's take written submissions in a leisure way. But they're telling you, but secure us in the meantime on an order that has no legal basis. With tremendous respect, my lord. They are the authors of their own misfortune, as it were. And they have only themselves to blame. So I would urge the court to decline that particular plea for conservatory orders. And in the meanwhile, we can have a limited time to respond. And since the petitioner has elected to go by way of written submissions, I am amenable to go by that. Although they do not state the time limitations they would like to cap for themselves. 3 days, 10 days, 7 days, I don't know. But we... Thank you.
What prejudice?
One, Article 10(2)(b) of our Constitution says that whenever anything is done, we are bound by the principle of the rule of law. Now, again, without wishing to vex your lordship and sounding redundant, these increments are bound contains Act of 2019. It was enacted into law on 25th of September 2019. That is a law. It is supposed to be complied with. Now, you're being asked to suspend that without an order being sought to suspend, declare unconstitutional, or otherwise. You're being asked, in other words, to usurp the role of the county assembly. You can't, with respect, my lord. The prejudice being suffered here is...
Praise that the application be determined by way of written submissions. And also 6, that interim orders be granted before hearing of the application. The respondent is opposed to granting conservatory orders as sought. I have considered rival submissions for granting the conservatory orders and against granting the conservatory orders. I have perused the notice of motion, the grounds in support and supporting affidavit, and note various constitutional issues as being raised in the application. There is also a number of grounds for seeking conservatory orders. It is further urged, if the interim orders are not granted, the petitioner will be prejudiced. The respondent opposed the granting of the conservatory orders, raising a number of issues as raised in the grounds of objection, from the rival submissions, the petitioner's petition. I am certified that the application raises prima facie case to warrant granting of interim orders sought pending hearing and determination of this application. I accordingly grant prayer B of the notice of motion dated 2nd December 2019 in the interim basis. I further direct that the notice of motion dated 2nd December 2019 be determined by way of written submissions. However, before the parties proceed to file the submissions, the respondent is granted leave to file and serve replying affidavit within, I have not decided a period. How long do you need?
My lord, I would request you to revise your orders with respect
I'm not finished. Let me read the order.
I see.
I'm asking you how many days do you want?
The reason I was saying that was
How
that.
many days do you want? I'm still in the middle of reading.
Yes. The reason I was saying that is that we waive the motion. Since you've given them conservatory orders to hold the status quo, we have the main petition.
Let me finish. Then
I'm obliged. I'm obliged. Give me.
I'll give you 7 days.
That's okay.
From today. The petitioner, upon receipt of the respondent's replying affidavit, to file and start submissions within 7 days from then. The respondents to file submissions in response within 7 days from the date of service.